In many states, courts may dissolve a limited liability company, or LLC, under statute for several reasons. For example, when carrying on the business isn't reasonably practicable in conformity with the operating agreement. But who has the standing to bring such a dissolution action? This was the question for the Delaware Court of Chancery in the case In re Carlisle Etcetera LLC. In 2012, Well Union Capital Limited, which we'll call WU Parent, and Tom James Company, which we'll call James, formed Carlisle Etcetera LLC and executed an initial operating agreement. The parties also planned to execute a more detailed operating agreement. Under the initial operating agreement, Carlisle's sole manager was its board of directors. The board consisted of 4 members, 2 appointed by WU Parent and 2 by James. Following formation, WU Parent transferred its member interest in Carlisle to its wholly owned subsidiary, Well Union U.S. Holdings, Incorporated, which we'll call WU Sub. James didn't object and treated WU Sub as a member. But under Delaware's Limited Liability Company Act, the transfer made WU Sub an assignee, not a member. Around the same time, the parties began drafting a more detailed operating agreement. The draft referred to WU Sub as a member of Carlisle, instead of WU Parent. Also, the draft provided that if an initial member transferred its membership interest to a wholly owned subsidiary, the subsidiary would be admitted automatically as a member. However, the draft was never signed. Ultimately, WU Parent and James never agreed on the detailed operating agreement. Further, other disputes arose over important business decisions, and the parties' relationship deteriorated. Subsequently, WU Sub filed a petition in Delaware Chancery Court against Carlisle and James, seeking judicial dissolution of Carlisle because of deadlock between its members and managers. In response, James moved to dismiss the petition, arguing that WU Sub lacked standing to seek dissolution because it wasn't a member. WU Sub then amended its petition and added WU Parent as a co-petitioner. The Delaware Court of Chancery considered the motion to dismiss.